traditional planning or sort of rules around that property. But it ends up creating a lot of problems, or at least doesn't protect against those problems coming up as an issue. They don't really provide the structure that someone might need to deal with disputes or how to pay for expenses. So what we're talking about today is really making sure that we, provide some information on what types of things people want to look out for when they're doing this planning, the considerations you need to have when you're setting this up so that you're guaranteeing success. Again, welcome everybody. I'm attorney Justin Randall here with Cooper Law Office. Our topic today is on family cabin planning, up north planning, legacy property planning, kind of call it what you want. Really talking about dealing with primarily real estate passing on to the next generation, where it's going to be used by multiple people or have multiple owners, or, you want it to kind of keep the family together and stay in the family. So before I go too in depth on that, just as a reminder, a couple of things with these, you can ask questions as I go along. There's a Q&A function, so I do see those questions come in, and I'll try to answer them and get to everybody I can. And we also will be sending out some materials to you regarding this topic today. So we have our tools for up north properties chart that we'll hand out to you, or send out to you rather. And then some just kind of a quick guide on different types of business structures, because we often use different business entities to own these properties as part of this planning. And then just a final reminder, you will also get a feedback form at the end of this that will let you fill out any sort of feedback you have, but it also gives you a place to let us know if you'd like to set up an initial consultation, or come in and talk to one of our attorneys. And we just, for anybody who may also be interested in attending our Drive into Healthy Aging event next week, or no, excuse me. It was originally on the 20th. It will now be on the 21st. So about a week and a half away, I suppose. But that has been changed to the 21st. It was moved because we didn't realize there was a Packers game that day, apparently. So we're making it so more people can come. Just to get started on all of this, I wanted to talk first about kind of what tends to happen with this legacy property planning, what most people do. And as I'm sure many of you are aware, what most people do is not necessarily, just because most people are doing it, doesn't make it the right thing to do or the best thing to do. All right, sometimes those things overlap, but not all the time. And most of the time when it comes to legal planning, especially with estate planning, what most people are doing, or what, the kind of advice you get on the internet for what to do with these types of properties is either not correct or not the full picture, or maybe, out of context, right? Maybe not even referencing the right state that you live in. So often with cabins, or lake properties, up north properties, people try to pass these on to their kids, and so that they stay in the family. They don't want it to go to spouses or somebody outside of the family. It's a property they have a lot of shared experience with, and it's meant to keep the family together. So, it's a really common goal we see, whether that's with lake property, just a, hunting land, sometimes family farms. All of these sorts of things can fall under this umbrella. But the things people try to do with them, they try to make it as easy as possible on the front end, but they don't do a lot of planning for what can go wrong with these properties, or, interpersonal relationship wise, if the proper structure is not set up for them. So the first is, I guess, kind of the do nothing approach, where somebody says, all right, I have a will or I have a trust, and I'm just going to split it up equally to the kids, right? I'm not going to do any planning around it at all. I'm just going to say they can decide what to do with it. There's no real restrictions around usage or paying payment of expenses or anything like that. It's just whatever they decide to do with it. Well, the reason that can be a problem is if you don't just anticipate them selling the property, right? If they're not just going to sell it and divide up the proceeds by the terms of the estate, that doesn't really provide a lot of structure for them. And it opens up a lot of possibilities for things going wrong. If they do just plan on selling it, that's probably fine, right? They're just splitting the estate. If you don't anticipate them actually using the property going forward, that's completely, acceptable planning. But if you do want them to use the property, if you do want it to stay in the family, and you do want to place these restrictions on it, sort of relying on handshake deals where the kids just say, oh, well, we'll never sell it, or we'll never give it to our spouses, right? Well, we will keep it in the family without anything binding them to that. That's not really planning. That's just sort of leaving it up to chance. But on top of that, often when somebody does want that to stay in the family, the goal is to keep the family together, right? It's something that it brought them together, a shared experience, right? And you don't want them to not have a way to deal with problems that come up. And there will be disputes that come up. I mean, there's always disagreements over common ownership, whether it's small or large, depends on the situation. I mean, it can be something as simple as, okay, the property taxes are due. Has everyone paid their fair share? How do you guarantee people pay their fair share of property taxes? What happens if they don't? Are there any sort of fallout? Is there any sort of fallout for that person for doing that, other than just the rest of the family being mad at them, right? Do they have any consequences for not pulling their weight? How is the property used? Do you have certain times of the year that you can use it? Sort of like a timeshare, I suppose, or are there, can it be a free-for-all? Anybody can use it all the time, right? So these are the things that lead to disputes more often than not, because sometimes it's a matter of fairness, right? Who is using the property the most? Are they paying more than for that usage? Are they, actually kind of more of an owner in that sense? How does it all work? There's a lot of these types of questions that need to be answered before people inherit. The best thing you can do is actually set up that structure for them now, because you have full control. You're not trying to get 6 people together to agree on the structure. You set up that structure, and then they have to follow it. And that is the best planning you can do if you want that property to stay in the family. So, if the kind of do nothing approach occurs, it's, as with anything, it's just not really planning, right? It may work as an estate plan, right? It may be a really good estate plan, but it's also not planning for what happens after that, especially with that type of property. When that approach is fine when it's a lot of assets that are just going to be divided up there, and they can go their separate ways. But if you intend for them to share the property, that's a problem. So the other, I guess, common approach you tend to see where things aren't done the best way they could be is when parents try to gift that property to them during life. They try to transfer that property now so that, it gets to them now. And this is often done with anticipation of maybe protecting that property from their long-term care expenses, or maybe they are just trying to gift it now because they want it to be gifted during lifetime. I suppose there could be a lot of reasons somebody would, go about it that way. But the problem is these, that gifting overlooks a lot of problems that creates. So one, if you're doing that for long-term care concerns, if you're trying to protect that property from long-term care expenses, you're not actually doing it the best way that possibly could be done. Because gifting still counts as a divestment for Medicaid, right? If you're transferring that property to somebody, and you may be familiar with Medicaid's 5-year look-back rule. Well, if you need care shortly thereafter, you've created a problem for yourself because you gave assets away that otherwise were available for your care. So that's a problem right there. The other is maybe you do make it out past that 5-year point. Maybe it's fully protected from your care. You didn't have a divestment because of it, because it was 5 years and a day before you went into the facility. So you might have protected it from your own care expenses and from Medicaid availability. That's possible. But what people often don't understand when they gift property is they actually open that property up then to not just, what would have just been their personal liabilities, whether that's long-term care or, creditors or whatever it is. But now you're opening it up to whoever is the new owner, their creditors, their liabilities. So you have to not just think about, okay, my own long-term care expenses might be coming up. How do I protect this asset? You also have to think about, who am I gifting this to? Who is receiving this? Can I guarantee you that person will never have any sort of lawsuit come up, or a divorce, or that they won't pass before me and that their spouse is their beneficiary, right? these are the sorts of things that gifting without a plan can really create a lot of problems for people. Because you don't want to protect something for yourself only to open it up to more liability, right? That doesn't really make a lot of sense in the long run. So that's a huge problem. There's plenty of examples of that happening too, where that can be a huge issue. But the other issue with gifting it's just terrible tax planning. So you might not ever anticipate the family selling the property, especially if it's meant to stay in the family, but you don't know that they won't need to, right? There could be a lot of reasons somebody needs to sell property, or maybe they really all do agree it's just time to sell it, right? That can happen. But if you gift property to somebody, real estate in particular, what you're doing is you're transferring your cost basis to that person. So for people who might be unfamiliar with what a cost basis is, think of it as, and this is a very basic definition, but think of it as, what did I buy that property for, right? What did I buy that property many, many years ago, and it was $50,000 when I bought that cabin, and now it's worth $300,000? Or was it very recent? You have to know those things to have a kind of an idea of what your cost basis might be. But when you gift something over to somebody that has a cost basis, the IRS says you are transferring that to that person too. So it looks like they bought that property for whatever you did when you bought it. Or maybe you inherited that property and it was in the 50s and it was worth a very low amount, and that's what your cost basis was, right? So if you transfer that to them and then they sell it for fair market value after that, they have capital gains to pay on that sale. And the rate of the capital gains can be anywhere from about 15% to 20-ish%, but that's based off of their tax brackets too. So that's not the most tax efficient way to pass it on. When you pass somebody real estate through your estate plan, and it is included in your estate, not outside of the estate for any reason, that gets an adjustment to fair market value, that cost basis. So what that means is when you transfer that to the kids, then it looks like they bought it for whatever the current fair market value was the day that they inherited it, or relatively close in time to when they inherited it anyway. So that means if they then turn around and sell it pretty quickly after that, they're not really paying any, if at least very little capital gains tax on it, because there might not be a gain at all or a very small gain. So that's the most tax efficient way to pass that on for sure. I mean, you don't want to just gift it to somebody if you think there's even a chance of them selling it. And I say if you think there's a chance, but in all likelihood, there probably is a chance that at some point somebody will need to sell the property, or at least sell their interest in the property. And it's just doing it in a tax efficient way, on top of not opening it up to a bunch of other people's liabilities and, only to protect it from your own. There's better ways to do these things. So really, you'll see a couple of different options that people would have when it comes to passing these on. I've seen, for example, somebody will do like a family cabin trust, or the family property trust, where they have it sort of as a pooled common trust for all the beneficiaries, where there's rules over it, right? Maybe they have restrictions, like if somebody wants out, they just lose their interest, right? They don't get to sell it. The other owners just take it. So if somebody doesn't want to pay their expenses and can't do that, maybe they just lose out. I mean, you could be that restrictive if you wanted to be. I mean, maybe that's not what is best for family harmony, but you could do that. Those family trusts often say things too, like where it goes after the other owners pass, right? Or the other beneficiaries of that trust pass. So maybe it has to stay in your direct descendant line. Maybe it can't go to spouses. How do you define those direct descendants, right? Is it adopted children as well? Or is it also stepchildren? So it can be done a lot of ways, but that is one tool I've seen used for it. I tend to prefer the second alternative myself, but I think it can depend on the situation. I tend to prefer using some sort of entity to own those types of assets. So whether that's, somebody owning it like as an LLC or some sort of, family partnership, I mean, however you own it, a business entity provides a lot of flexibility to the structure of ownership. You can place a lot of rules on, how are expenses paid, how are they divided up. who's in charge of making certain decisions, right? And you can also limit who can be an owner of that entity. So does it have to be defined as like somebody who's your descendant, or does it have to, is it a little more broad? Could it also include spouses? You can be very flexible with this, but also, and I say flexible, meaning flexible on your end, setting it up, but you can also then dictate what those rules are going forward. So a lot of times we'll use like an LLC to own a property. Well, this does a couple of things for that family property, right? One, it provides that ownership structure. It provides different tools for dispute resolution. It provides mechanisms for somebody getting out of the property. But it also potentially provides some liability protection from the entity or from the property itself. So what people often misunderstand about LLCs is they think what's in the LLC, that's, you know, fully protected from all liability. And it can provide some protection, especially with multiple owners, but it's not, that's not the main purpose of it. Really, an LLC is designed mostly to protect the owners of that LLC from the liability of that entity. So that's why you often see businesses set up as LLCs, because the owners don't want personally to be held liable for maybe a debt of the business, although that's sometimes they sign personal guarantees. But when it comes to like family cabins, I mean, especially with multiple owners, the big concern I have is, are you aware of everybody on the property at all times? Are you, you know, do you know all of your family member and other owners' friends and people who might be on there? Are you prepared if one of them gets injured due to, you know, negligence or something like that on the property? Are you prepared to, you know, cough up potentially for the expenses because you're liable now as an owner? I mean, these are the sorts of things that, you know, you hope never happen, and maybe they never do, but that's not the point of doing protection, is because of, well, it might never happen. Well, it also might. So you want to protect against things that you're not sure you can prevent. And in this case, there's just no way of guaranteeing you would prevent any sort of liability with the property, right? I mean, nobody can promise that. Insurance is one way to protect that liability too, but insurance is a tool on top of something like an LLC to protect that liability or the individual person from that liability. So it can, LLCs or different types of limited liability entities can be very helpful to a family to make sure that if something does happen on that property, worst case scenario is somebody can come after that property, but they can't come after the individual owner's assets, right? But it also protects against the, you know, making sure that passes on the right way. So a lot of LLC operating agreements will have rules in place that say, you know, when an owner dies, the other owners either have like the right of first refusal on that ownership to buy it from the estate, or it can't go to spouses. So it could go to a descendant, but not a spouse. I mean, there's a lot of those types of rules that we often put in place because of the goals of keeping it in the family. On top of just limiting who can be an owner, a really important thing that people often overlook, and this includes LLCs, I mean, even people who might have an LLC set up for their family property, is, are you restricting the number of owners that could potentially be, you know, an owner of that property? So the first generation doesn't always seem that bad, right? It doesn't seem that awful to have 5 owners of a family cabin where you're splitting the LLC that way. But if you only limit that potentially to descendants, right? And well, what happens with the next generation? Now, do those 5 owners become 25? Do they become 30? What happens after the generation after that? Do you start to have hundreds of owners? I mean, this can get big very quickly. And that is a huge headache. I mean, think about trying to manage a property, making decisions with potentially a couple dozen people owning it or having a right to weigh in on that decision for something as simple as, okay, it's time to collect the tax bill, right? Or how do we split up usage of this property if there's 36 people who own it? And, you know, how do we divide the year up and who gets what weekend? I mean, that could be, that is a panic attack waiting to happen, I think. So, you know, one of those things that you want to do is think about, do we want to limit it to a maximum number of owners? Does it have to be one person from each family? So if originally, right, I say I had 4 kids, if I only want maximum 4 owners, do I put that type of restriction in there? Do I say it can't, you can't give your share to more than one person? Does it have to go one person in each family? And that obviously doesn't create a lot of flexibility. It can create some tension in some ways of, okay, well, which kid gets that interest then? But for in the long run, having a limited amount of owners helps everybody, because you're not going to run into a situation where you have to somehow get 30 something people together to make a decision. Really, to the biggest reason to set up this sort of structure, I sort of alluded to it earlier, but or any sort of planning with family property, is making sure that if somebody does need to get out of that ownership for any reason, that they're not stuck. So I talked a lot about people maybe not pulling their weight or not paying their fair share of expenses, but it can also be things like they have financial difficulties and they can't, right? Or they have creditor problems coming in, and you want to make sure that, that doesn't happen to the property, right? It doesn't attach to their property. Or, maybe they're getting a divorce, or they have substance abuse concerns. I mean, any of those sorts of things that can impact the family property. Maybe they have financial difficulties in general. Maybe they lost their job, so they just need the money from it. Well, the problem with family property, where it's actually owned by individual owners, is there's no structure for how to get out of that. If maybe one of the family members is willing to buy that person's share, but what happens if they're not? You can't necessarily, I mean, legally speaking, you can try to sell it on the open market, that interest, but the question becomes, who wants to buy like a 1/4 share of a family property with a family they don't know? Most people are not going to be willing to do that. And maybe the other owners aren't all that happy about that either. So they're both unwilling to buy the property, or maybe unable to buy the property for financial reasons of their own. But then that person also is unable to sell it. So it puts people in sort of a gridlock situation where there's nothing they can do. And the only solution to that can be potentially a forced judicial sale, right? If somebody has to go to court and they say, all right, it's on the open market if nobody wants to buy it, then, because you can't force someone into a property that they cannot afford, forever. Eventually something has to be done. And that obviously defeats the entire purpose of that type of plan, where you're saying, I wanted this to stay in the family. I wanted it to keep the family together. If that sort of tension comes up, or that sort of forced situation comes up, you didn't avoid anything. You just made it more expensive. It would have been cheaper to sell the property when you passed, or sell it during your lifetime and then split the proceeds, right? You would have been ahead in that situation if you end up with like a forced judicial sale. You do not want that situation. It's expensive. It completely can, get in the way of family harmony, for one, and that's obviously not the goal of that plan. So setting up an LLC with the right sort of terms of, okay, here's what happens if somebody doesn't pay their expenses. Does it start to eat away at their ownership, right? Can eventually they just be essentially bought out for forgiveness of that debt? I mean, those are the sorts of things you want to think about when you're doing this planning. And there's never going to be a 100% right or wrong answer to any of those questions. It depends situation. It's completely situational, but those are the things you need to think about. And I know those are a lot of various sort of things that can come up, but if you're not thinking about them, if you don't have the answers to those questions, or you're saying, well, I never really thought about it that way, so I don't have any plan like that in place. That's why it's so important to have these discussions, because without thinking about what can happen, you can't be prepared for it. So having a structure in place to deal with those, whether or not you're personally prepared for those things to happen, or whether or not you even think they're going to happen, that structure should be set up in a way where there's tools to deal with disputes, tools to deal with, potential liabilities, whatever the situation might be. So the worst thing someone can do with this type of plan really is just leave it directly to a bunch of people with, split shares of ownership, no structure in place, no rules in place. That's where problems come up. because there's just nothing in place to deal with it. And now they're just individuals who own it and are subject to their own rules and responsibilities that they may decide to have, or, they're just not agreeing on any one set of rules for themselves. So I guess to finish up here, I do want to leave you with, I did just read a real world story that kind of reminded me of this. I cannot remember where I read this, but it was also very timely because it was something that dealt with, the pandemic, right? And so this story was about a family, I believe it was like the Jersey Shore or something like that, somewhere on the East Coast. They had the grandparents gifted to the family, split multiple ways. I can't remember how many, but they essentially, it was a property with 2 buildings on it, 2 homes on the shore. And during the pandemic, one of the uncles decided, all right, I'm gonna start using this one of the buildings. I'm gonna live there because New York City was stressful, and they felt a little more at risk in the big city during the pandemic. Well, they moved there, and the family started to feel that, well, we don't want to use the property. We feel like we're intruding now on our family property because they moved in. And, it sounds like the person who moved in was very, yeah, go ahead, use the other building whenever you want. But there was no structure in place to deal with that, right? There was no way for them to outvote that person, or to say, I'm sorry, you can't live there while the rest of us, just want to use it as a vacation property. There was no structure in place for that. And the reason this article was being written was because there was a dispute. So it sounds like, nobody was really meant any real ill will about that situation, but it clearly caused tensions. So that's the type of thing, though, that without a structure in place of what's the usage of the property going to look like going forward, do you have certain times you can use it? That can happen, right? Are there rules against someone using it as a primary residence? If not, nothing's going to stop them from doing that. In theory, there's nothing that can be done to kick them out without, everyone agreeing to sell, or potentially a judicial action. And it's just not worth trying to sue a family member or force that situation when you could have avoided it entirely with something as simple as getting together as a family, or before you even pass it on, getting together with your spouse and saying, all right, what rules do we want to enforce? What rules do we want to create around the usage of this property to avoid conflict down the road? So with that, I'm not seeing any questions, but if any of this raised concerns for you, or you have a family property that you're trying to pass on and you want to come in and talk to one of us, just remember that you can schedule an initial consultation with us through that feedback form, or just give us a call too. Those are complimentary initial consultations. They don't cost you anything to come in and talk to us. They are usually scheduled for around 2 hours. So if that's something you're interested in, you can absolutely do that. Otherwise, I hope everyone has a great weekend, and we will see you guys next week.